Now I'm not for sure who can hear this video or is even watching it, or whoever gives a shit to watch it. Just maybe one of you just might pick up the seed of education versus sitting back watching some politicians race across the nation, soliciting your votes while they plant seeds of destruction amongst you folks in your neighborhood, with your neighbors, with your family and your loved ones. They pitch you right back and forth at each other and then turn around and get you to vote for them fools. Man, and you don't even have the audacity to admit that you're such a sucker. But never mind the suckerness. You know, they keep a lot of things from you. And some of the things that they keep from you is probably for your own benefit, I must admit. But never mind your benefit. They definitely take advantage of it and they put it to use for their benefit by using your ignorance to champion and convince you to make decisions that are detrimental just because of a lack of education or understanding, so on and so forth. So, when you're negligent, it's when you fail to operate safely. And when you're operating something, even as a truck driver, you have a duty for a standard of care. And that duty is owed to another, which is like, as a truck driver, you owe a standard of care to the people around you. Make sure you operate your 80,000 pound vehicle with care. Because it is a big vehicle, isn't it? Yeah, for those of you who don't know. And if you're dangerously driving that vehicle and you end up hurting someone, then you're liable for that harm that you've caused in all senses. It doesn't matter what you're driving. All that matters is you was looking down at Facebook, getting your face looked when you wasn't paying attention and you crashed. Or you was going the wrong way without your lights and sirens, violating a vehicle code that the statute was designed to protect. Ain't that something? So, I'm just sharing with you some of the things that I've learned along the way, my litigation, and I'm explaining some things to you because some of you out there, you know, don't know where to start, and even myself, I didn't know where to start. But I didn't start from nowhere. I started from thin air. That's better than nowhere. Thin air can't be located. Nowhere, you can find somewhere. The truth is, the word negligence is, as it says, it's not always been used to refer to a particular tort. A tort's like a lawsuit. Before 1800s, there was relatively rare in the English American court or whatever. But you have to go back in history to start to understand this. So if you were start to understand it, you would know that a trespass is anything that touches another's property and without their consent causes them harm, destroys the property, then or go on to someone else's premises without their consent. That's the same as touching them without their permission, which is a generic legal wrong that covered any direct and forcible infliction of an injury by an actor upon a victim, whether intentional or careless, rather intentionally or careless. So, meanwhile, let's say a subject of the government entity who inflicted an injury claimed to have been injured by the unlawful detainment of this government entity, and it would bring the action of a trespass or unlawful detention. Well, whether these differences are in a categorization of reflect, it's substantive differences in the doctrine, is the debate among historians. Yeah, they debate against everything. They'll, they'll debate over a bagel with "I can't believe it's not butter" and call it whipped cream. Wow, nothing but an artful argument. So, what am I showing you this for? Never mind that. Take in a little bit of knowledge, hear it, seek it, educate yourself. A prima facie case is an actor that is subject to a liability to another person for negligence if the person has suffered an injury, owed a duty to a class of persons, including the persons to take care not to cause an injury of the kind suffered. I got this figured out for you. Check it out. A breach of that duty of care and a breach that was actual proximate cause of the injury. Now check this out. So another way that I'm going to put this to you is like this. This opposition with negligence and the difference here with prima facie evidence or prima facie negligence is the same as negligence per se, which arises from the statutory violations where an actor or an employee is negligent if they, without excuse, violate a statute. In this case, the statutes are a motor vehicle violation. They violate the Motor Vehicle Code of California Vehicle Code sections 21,055 and 21,806, which are designed to protect against the type of accident that caused the harm by the defendant's actions. The defendants, overall, they will more than likely appear and misrepresent who they actually represent. No joke. So, some other examples is the injury elements, and there's many standard formulations or whatever as the injuries. What I'm actually showing you here is a CaseBook Connect that I have an account with because a good friend of mine bought me some used books and they still had the codes in them. So I scratched them off and I registered the account. And bam, I got up in there. And it's just one of the main, few books that I have. Uh, there's a lot of valuable information in here, like the procedures of civil procedure for civil cases. This has nothing to do with criminal cases or criminal codes. If you're over here looking for criminal information, you came to the wrong place. This has nothing. I'm not going to help you get out of your traffic citation, your criminal lawsuit, or whatever. I'm just going to tell you some of the things that I've learned regarding civil lawsuits, especially if you've been injured and you're litigating the claim on your own without the help of a shicer ass attorney running around town licking the paws of every clown he can for some thrifty greens that have no meaning. His only meaning is his client's loyalty. No joke. But anyway, you could say you got civil procedures, right? So civil procedures are in state courts, and especially in California, you have Civil Code of Civil Procedure. And in the Civil Code of Civil Procedure, it's basically the rules of the court. It's basically situating, telling you exactly what the rules are of the court, what you can and can't do, uh, what the requirements are for doing certain things. Um, you have to raise your hand and be nice. Um, you're not allowed to be rude and disrespectful. You don't have absolute speech. Freedom of speech is not absolute anyway, but they like to say that it is and they act as if it is, but you cannot enforce a fraudulent contract. That's what I did learn. Um, Let me get this fixed up here for you. Get that one right there. So you got like uh,
C44A.L.3D 822, and this is in accord with Restatement of Conflicts of Laws, Section 30, that a minor child has the same domicile as its father. In these days, when nearly all the state legislatures have reduced the age of majority to 18, this poses a more pressing problem with respect to college students who can no longer be put off with the explanation that those under 21 are minors and hence continue their residence with their parents. The plaintiff Susan Gordon is one of those who was benefited by the provisions of the aforesaid Emancipation Acts of June 16, 1972. She was born November 20th, 1953, and hence was 18 years of age at the time the cause of action herein mentioned arose, and was 19 at the time this action was brought, April 10th, 1973. The action is one for malpractice against 2 physicians and an osteopathic hospital in Erie County, Pennsylvania. All of the defendants are citizens of Pennsylvania. There seems little question that prior to August 9, 1972, the plaintiff was also a citizen of Pennsylvania, residing at 227 Goodrich Street, Erie, Pennsylvania, with her parents, and if this continued to be her address, her suit must fail for lack of diversity jurisdiction. She complains that she suffered an injury to her wrist on February 25, 1972, and there was wrongful
diversity jurisdiction. Get that up for you. Diversity jurisdiction is one of a kind. Uh, I believe it's either 28 or 26, 1332A. Diversity jurisdiction. Uh, 28, 1332A. So, diversity jurisdiction. The court shall have original jurisdiction over all civil actions where the matter in controversy exceeds the sum of $75,000 in value. Exclusive interest of cost and is between A1, citizens of a different state, citizens of a state, and citizens or subject to a foreign state, except the district courts shall not have original jurisdiction under this subsection of an action between a citizen of a state and a citizen or subjects of a foreign state who are lawfully admitted for permanent residence in the United States and are domiciled in the same state. Citizens of a different state and in which citizens are subject to a foreign state additional parties, that's the key, or are additional parties. A foreign state defined in section 1603A of this title as plaintiff as a citizen of a state or different states. So, diversity of citizenship clause exists when a citizen of the state of California sues a citizen of Georgia. They're of different states, and each state is regardless foreign to each other. Even though they are in the United States, the diversity exists between the citizens of 2 separate states. Now, the question for the diversity jurisdiction is the value of the claim in excess of $75,000. It cannot be exactly $75,000. So you got to find your relief. Here you have the citizens of different states, and then you have subject matter jurisdiction, 1441. You have every state is a foreign state, which of the insured as a citizen, which the insured is a citizen. See that? Every class, a class means a class member. It can even be a cyclist or a pedestrian on the roadway, or a driver of a motor vehicle, or a specific kind of motor vehicle, or an individual of a certain entity. Um, it, it, the federal jurisdiction also exists when it's certain types of law, because federal courts are a court of minimum jurisdiction. They do not have unlimited jurisdiction. Federal courts are a court of minimum jurisdiction, and they're only authorized to hear certain types of claims brought before them. Examples are like maritime, civil rights, copyright, what else? Maritime, admiralty. There's only a handful of them. But the state courts, on the other hand, have unlimited jurisdiction. They have the authority to basically run butt naked in the street if they like. They pretty much do every time they encounter you, or you show up to pay one of them ridiculous sums of administrative citations being misrepresented as a criminal charge. What a life. Just getting ripped off every time you turn around. Go back over here. Just slinging some stuff down for you so you can get this. Yes, sir.
Wrongful diagnosis as to the existence of fractures in the bones by the defendants at that time. She claims that they concluded that there were no such fractures, and that as a result she endured continuing pain and disability resulting in hospitalization and medical attention, and that her wrist and right hand remain at least partly disabled as the result of the alleged malpractice. On August 9, 1972, plaintiff enrolled in Ricks College at Rexburg, Idaho, where she rented an apartment, which she has retained ever since. Defendants on January 21, 1974, moved to dismiss for lack of diversity. Briefs have been filed, arguments held, and the court postponed decision on the matter until further depositions of the plaintiff could be taken. The matter is now before the court for disposition. We approach the problem recognizing, of course, that it is citizenship at the time of filing suit, in this case April 10, 1973, which is controlling. Further, the rule is unquestioned that where plaintiff is challenged on her claim of diversity, the burden is upon her to show by convincing evidence that diversity jurisdiction exists. As is required in all of such cases, we must reckon up the indicators pointing for and against acquisition of a new domicile for diversity jurisdiction purposes. Defendant claims that the following indicate that plaintiff is still a citizen of Pennsylvania and has not acquired a new residence or citizenship in Idaho. 1. At the time of application for admission to the college at Rexburg, Idaho, she gave her address as Erie, Pennsylvania. 2. The college records dated in 1972 show her address as Erie, Pennsylvania. The same is true of the college records dated May 4, 1973. 3. During summer vacations, she worked in Erie, Pennsylvania. 4. She held a Pennsylvania driver's license and had a bank account in Erie. 5.
So in all, it's saying she never changed her domicile or her address from her hometown in Erie, Pennsylvania. She's always used that address and resided there. So in pretty much the sense, correct me if I'm wrong, she's a citizen and resident of Erie, and her permanent domicile is there, and she obviously has no intention of leaving.
5. She came to Erie for Christmas vacations. 6. 6. While Ricks College is a Mormon church institution, the supplemental depositions, which were taken at the request of the court, indicate that females, unlike males, are generally not required to participate in the missionary activity of the church, and that she has no present intentions of participating in such missionary work which, of course, might take her to any part of the world. On the other side of the ledger, plaintiff points to the following. 1. Her expressed intention is not to return to Pennsylvania. This, of course, is a very strong factor in a situation where subjective intent plays a part in determining what is her animo munendi. 2. She has an apartment in Rexburg, which she regards as her residence, and this is not sublet during various times of the year, but remains hers. 3. She states she came back to Erie only one summer in 1973 because of her eye problems, and that she took eye treatment in Erie and Cleveland. 4. She claims that her purpose in visiting at Christmas 1973 was to be deposed and for medical appointments. She has not returned to Erie during spring or Thanksgiving vacations. 5. Her religious desires as a sincere Mormon are to further her faith and ensure that she marries in a Mormon temple to someone of her faith. At the present time, she has no present plans of marrying anyone, but she does desire to marry in her faith and claims that the opportunities for such a marriage in Erie are very small and that she would be unable to marry in a temple here. 6. She has introduced exhibits showing that she is a member of the Blue Cross of Idaho, becoming a subscriber in 1972. 7. She claims she may locate after graduation in any other of the 49 states or abroad. She may, of course, return to Pennsylvania. She, like many other females, has vague intentions of marrying someday, but does not know to whom, and in such case it is likely that she would follow her husband where his work may take him. We recognize that the problem of students' residence is not altogether a new one, but has concerned the federal courts since Chicago and Northwestern Railway Company versus Oley, 117 U.S. 123, 1886, where the court held that determinations of a domicile were a matter to be determined by the trier of fact. The most recent exposition of the law on this subject for our edification by the Third Circuit is found in Crasson v. Dinnan, 465 F.2 D. 1298, 3D Circle 1972, from which we quote at length. It is the citizenship of the parties at the time the action is commenced which is controlling. Bruff v. Strathman Supply Company, 358 F.2 D. 374, 3D Circle 1966. One domiciled in a state when a suit is begun is a citizen of that state within the meaning of the Constitution, Art. 3, Section 2, and the Judicial Code. The fact of residency must be coupled with a finding of intent to remain indefinitely. Proof of intent to remain permanently is not the test. If the new state is to be one's home for an indefinite period of time, he has acquired a new domicile. Gallagher v. Philadelphia Transp. Company, Supra, 185 F.2 D. 543, at 546. Where jurisdictional allegations are traversed, as here, the burden of showing that the federal court has jurisdiction rests upon the complainants. In determining whether a party has intended to establish a domicile in the state to which he has moved, the fact finder will look to such circumstances as his declarations, exercise of political rights, payment of personal taxes, house of residence, and place of business. Applying these principles to the evidence before the fact finder, we cannot construe, as clearly erroneous, its finding that the defendant intended to remain in the Commonwealth for an indefinite period of time. Because animo munendi is at best a subjective manifestation, Dinnan's own declarations of intent are important, as were his explanations of the lack of compulsion in religious order assignments and his failure to obtain a Pennsylvania driver's license. We also have further instruction on this subject in the case in Judge Hasty's opinion in Gallagher v. Philadelphia Transportation Company, 185 F.2 D. 543, 3D Circle 1950, in which the lower court was criticized as putting too much emphasis on permanence of the attachment to a given state. We also quote at length from this decision. The emphasis of the court on the permanence of the anticipated attachment to a state, in our opinion, required too much of the plaintiff.
I'm going to tell you why, if you're listening. This is why. Because you cannot charge a fee for a right and exchange it for a privilege, and then upon receiving the payment of the fee that was exchanged for the right, only then can you enjoy the privilege. It is in a sense extortion and a concert of actions. It's too much on the plaintiff. And then it talks about failure to get a driver's license. Whoa. Whoa, whoa, whoa. So something that's hard to find. USC 1028 Chapter 1508. Do it like this. Three forms of driver's license. You got three forms of ID. My bad. Section 1028, Title 18, designates three special, says special, non-federal identification documents and gives them the preferred treatment. Now you better go look up what the word preferred means. Now I'm not going to read this to you. I'll just let the reader read it out.
Are the prime means by which an individual establishes his identity in the United States. The three documents are A. Birth certificate, B. Driver's license, and C. Personal identification card. Birth certificate is not defined in 18 U.S.C. Section 1028 since it is self-explanatory. This document is issued by different agencies in different states and foreign countries. Nevertheless, it represents the official governmental statement by the proper government agency that a person having such a name was born on a particular date in a particular place of specific parentage. Obviously, a birth certificate is not intended to actually identify the person who claims such a document pertains to him. There are few physical characteristics that remain the same as those at the time of birth. Nevertheless, the birth certificate has become commonly accepted as an identification document in this country. Driver's license is not defined in 18 U.S.C. Section 1028. The original purpose of this government-issued document was to state that a particular person was authorized to operate a vehicle upon the public roadways. It was not intended to establish one's identity. Because of the absence of a better document, however, the driver's license eventually has become commonly accepted as the national identity card. Section 1028 covers driver's license is not defined in 18 U.S.C. Section 1028. The original purpose of this government-issued document was to state that a particular person was authorized to operate a vehicle upon the public roadways. It was not intended to establish one's identity. Because of the absence of a better document, however, the driver's license eventually has become commonly accepted as the national driver's license is not defined in 18 U.S.C. Section 1028. The original purpose of this government-issued document was to state that a particular person was authorized to operate a vehicle upon the public roadways. It was not intended to establish one's identity. Because of the absence of a better document, however, the driver's license eventually has become commonly accepted as the national identity card. Section 1028 covers both domestic as well as foreign government-issued driver's licenses. Driver's license is not defined in 18 U.S.C. Section 1028. The original purpose driver's license is not defined in 18 U.S.C. Section 1028. The original purpose of this government-issued document was to state that a particular person was authorized to operate a vehicle upon the public roadways. It was not intended to establish one's identity. Because of the absence of a better document, however, the driver's license eventually has become commonly accepted as the national identity card. Section 1028 covers both domestic as well as foreign government-issued driver's licenses. Personal identification card is defined in 18 U.S.C. Section 1028 D to mean an identification document issued by a state or local government solely for the purpose of identification. This definition would appear to limit such documents to those issued by domestic, i.e., within the United States, governmental entities in contrast to the first two, birth certificates and driver's licenses. This document is normally issued by state departments of motor vehicles to provide an identification document for those persons who do not for some reason obtain a driver's license. In 1979, the National Committee on Uniform Traffic Laws and Ordinances, authors of the Uniform Vehicle Code, UVC, provided for the issuance of identification cards for non-drivers and restrictions on the unlawful use of such cards. The UVC, which serves as the model state code for vehicular matters, defines a personal identification card as a document issued by the Department of Motor Vehicles for the sole purpose of identifying the bearer and not authorized for use as a driver's license. Plaintiff. It is enough to intend to make the new state one's home. It is. We also have further instruction on this subject in the case in Judge Hasty's opinion in Gallagher v. Philadelphia. Applying these principles to the evidence before the fact finder, we cannot construe, as clearly erroneous, its finding that the defendant intended to remain in the Commonwealth for an indefinite period of time. Because animo menendi is at best a subjective manifestation, Dinan's own declarations of intent are important, as were his explanations of the lack of compulsion in religious order assignments and his failure to obtain a
Animo menendi. Animo menendi. Animo menendi.
Pennsylvania driver's license. We also have further instruction on this subject in the case in Judge Hasty's opinion in Gallagher v. Philadelphia Transportation Company, 185 F.2d 543, 3d Circle 1950, in which the lower court was criticized as putting too much emphasis on permanence of the attachment to a given state. We also quote at length from this decision. The emphasis of the court on the permanence of the anticipated attachment to a state, in our opinion, required too much of the plaintiff. It is enough to intend to make the new state one's home. It is not important if there is within contemplation a vague possibility of eventually going elsewhere, or even of returning whence one came. If the new state is to be one's home for an indefinite period of time, he has acquired a new domicile. Finally, it is the intention at the time of arrival which is important. The fact that the plaintiff may later have acquired doubts about remaining in her new home or may have been called upon to leave it is not relevant, so long as the subsequent doubt or the circumstance of the leaving does not indicate that the intention to make the place the plaintiff's home never existed. In the light of the foregoing and in view of the current tendency to treat students 18 years of age and above as emancipated, and particularly in view of the fact that in this case the plaintiff has rented an apartment in Rexburg, and with due regard for Judge Goodrich's statement from his handbook of the conflict of laws that the possibility of eventually going elsewhere or even returning notes and questions applying the test for state citizenship. 1. The common law concept of domicile. The court holds that Susan Gordon's state citizenship depends upon her domicile. To determine that, the court uses a further test, residence with the intent to remain indefinitely. This test was not created out of whole cloth. The common law concept of domicile has long been used for several purposes. It may, for example, be used to determine the power to exercise personal jurisdiction over a person, to grant a divorce, to impose a tax, or to determine the person's entitled to inherit property. Restatement, 2nd, of Conflict of Laws Section 11 CMT. C. 1989. 2. Losing and gaining a domicile. Courts hold that a person does not lose her old domicile until she acquires a new one, that is, until she goes to another state with the intent to reside indefinitely in the new state. With this corollary of the domicile test in mind, consider the following scenario. Susan Gordon, after growing up in Pennsylvania, goes to Rick's College. College in Idaho, planning to get a 2-year nursing degree and return to practice nursing in Pennsylvania. 2 months after starting school, she files suit in a Pennsylvania federal district court against Dr. Rodriguez, a Pennsylvania citizen who treated her in Pennsylvania for an injury. She claims jurisdiction based on diversity. The court probably lacks diversity jurisdiction because Gordon is still domiciled in Pennsylvania. Lacks diversity jurisdiction because the treatment took place in Pennsylvania. Has diversity jurisdiction because she was living in Idaho when she filed the suit. Would have diversity jurisdiction if she brought the action in an Idaho federal court. Several of the distractors, wrong choices, here reflect misconceptions about diversity. B is wrong because the court's jurisdiction in a diversity case has nothing to do with where the claim arose, only with the state citizenship of the parties. If Kim, from Texas, has an accident with Olson, from Michigan, in Tennessee, that's a diversity case, since the parties are from different states. The federal court will have subject matter jurisdiction over it whether it is brought in a federal court in Texas or Tennessee or Alaska. D is also wrong because diversity does not have anything to do with which federal district court the suit is filed in, only whether the plaintiffs and defendants are from different states. C fails as well, because a person may be living in a state, but not be domiciled there under the test, if she plans to leave at a definite time. Based on the domicile test, the best answer is A. Since Gordon is in Idaho for a definite time only, she did not acquire a new domicile when she went to Ricks College. Thus we look back to her last domicile, Pennsylvania. With that warm-up, consider where Susan Gordon would be domiciled in the following examples. Susan Gordon goes to Ricks College, planning to get a 2-year nursing degree and then move to California to work in a hospital there. Before leaving for Ricks College, she announces to her friends that she is never coming back to Pennsylvania. 2 months after starting school, she sues the Pennsylvania doctors. Susan Gordon goes from Pennsylvania to Ricks College, planning to get her degree and practice nursing in Idaho. After 3 months at college, she decides that she does not like Idaho and will return to Pennsylvania after she completes her degree. The next week, she brings the suit. Susan Gordon goes from Pennsylvania to Ricks College, planning to get her degree and practice nursing in California. After 3 months at college, she decides she likes Idaho and will stay and practice nursing there after she completes her degree. She brings suit a month after she makes that decision. Susan Gordon goes from Pennsylvania to Ricks College, planning to practice nursing after she finishes her degree, but with no plan as to where she will do so. A month after starting school, she sues the Pennsylvania defendants. A. Pennsylvania. She has not formed a new domicile in Idaho, since she is only in Idaho for a definite period. She hasn't formed one in California either, because she hasn't moved there yet. Ironically, though she swears she will never set foot in Pennsylvania again, she does not lose her Pennsylvania domicile until she forms a new one. B. Idaho. When Gordon arrived in Idaho planning to stay, she acquired domicile there. Although she now intends to leave Idaho, she won't lose her Idaho domicile until she goes to another state with the intent to remain there indefinitely. C. Idaho. Gordon did not acquire domicile when she moved to Idaho, but did when her intent changed while she was living there. The statement quoted in Gordon that it is the intention at the time of arrival, which is important, is misleading. Even though Gordon did not form a domicile on the day she moved there, she does form it later when she is living there and decides to stay. D. Here, Gordon has no clear intent to leave Idaho. She might, but has no definite plan to do so or to do anything else. The better answer is that she acquires domicile in Idaho. This is close to the actual facts of the case. 3. Meaning of indefinite intent. What does it mean to intend to remain indefinitely in a state? It is often said that this prong of the domicile test is not met if a person goes to a state temporarily, that is, to visit. On the other hand, it is not necessary to intend to remain permanently to meet the test. How many Americans today could testify that they live in a state permanently? Often, courts state that it is enough that the party intends to make the new state home and that the person has no present intention of going elsewhere to live. Wright and Kane section 26. If so, the person is in the state on an open-ended basis and establishes a new domicile. For applying the test. In Holmes v. Sopok, 639 F.2 D 431, 8th Circle 1981, the plaintiff, Holmes, had been living in Missouri and working for the Federal Defense Mapping Agency. The DMA sent him to a 1-year program at Ohio State University during the 1978-79 academic year. He and his wife moved to Ohio, where they leased an apartment for 1 year. In February 1979, while he was still living in Ohio, he brought a diversity action against 2 Missouri citizens. Holmes testified that after finishing his studies at Ohio State, he would obtain the best position available with the DMA and that he never intended Ohio to be his permanent home. Moreover, there is no DMA facility in Ohio which Holmes might have chosen upon the completion of his studies. Holmes also testified that he might have chosen to return to the St. Louis DMA facility. Did Holmes acquire domicile in Ohio?
No.
The court held that Holmes did not acquire domicile in Ohio during his time there. Although he resided there, he was not there indefinitely. He intended to leave Ohio at a definite time, since he planned to resume his work for the DMA, and he could only do so by leaving Ohio. The result would likely have been different if the DMA had a facility in Ohio, and Holmes might have been hired there. In that case, he might have remained in Ohio after the 1-year program. Even if there were more DMA offices in other states, it would not be clear that Holmes was going to leave Ohio at a definite time. 5. An alternative formulation of the domicile test. Some courts may state the domicile test a little differently. To establish a domicile of choice, a person generally must be physically present at the location and intend to make that place his home for the time at least. Sadat vs. Metes, 615 F.2 D 1176, 7th Circle 1980. This test is meaningfully different from the intent to remain indefinitely test. How would Holmes's case in Note 4 come out under this test? Under this test, Holmes would become a citizen of Ohio, since he was there for the time at least. However, most diversity cases have applied the intent to remain indefinitely test. The Holmes court rejected plaintiff's argument for the alternative test. 639 F.2d at 433 to 34. As previously noted, domicile is a common law concept. Concept used in many contexts, so it may be applied somewhat differently in one context than another. 6. The date for determining diversity. The Gordon Court states the long-established rule, c.e.g., Smith v. Sperling, 354 U.S. 91, 93, 1957, that the parties must be diverse on the day the complaint is filed. If the parties are diverse on that date, the case is a proper diversity case, even if the parties were not diverse at the time of the events giving rise to the claim, or later in the litigation. In Levitt v. Scott, 338 F.2d 749, 10th Circle 1964, the plaintiff was from Utah and had an accident with another Utah citizen. He moved to Colorado briefly and brought suit against the defendant. Although he returned to live in Utah after filing suit, the court upheld diversity jurisdiction since the parties were diverse on the date of filing. If the underlying rationale for diversity is prejudice against an out-of-stater, why determine diversity based on a single day? And why choose the day of filing? Wouldn't the day of trial make more sense? Or why not require the parties to be diverse throughout the litigation? Or on the day the claim arose, a date likely beyond the power of either party to manipulate? Ultimately, the choice to focus on the party's domicile on a single day is a matter of administrative simplicity. The court has to know whether it has jurisdiction or not. Choosing the date of filing provides this certainty. Using the date the claim arose would be dubious in cases that arise over a period of time, such as claims for unfair competition or sexual discrimination toward an employee. If the court used the day of trial, a court might process a case through the pre-trial stages for a year or more, only to discover, because a party moved, that it no longer had jurisdiction. The day of filing seems a bit arbitrary, but it promotes efficiency by providing a clear test for jurisdiction, which will not change even if the parties later change their domiciles. 7. Evidence of domicile contrasted with the test for domicile. The courts consider a wide variety of evidence in determining a party's domicile. In Gordon, the court considers evidence about Susan Gordon's driver's license, her health insurance, her apartment, her religious affiliation, and other facts. Yet these practical facts are not the test itself, they are evidence relevant to applying the test. In some situations, most of these facts would point to one state, but the person would still lack the subjective intent to remain there indefinitely. Consider, for example, a student who graduates from medical school in Indiana and starts a 3-year residency at a Texas hospital, planning to return to Indiana to establish a practice. Wouldn't she rent an apartment, join a health plan, get a driver's license, pay local taxes, and do other things suggesting a local affiliation? Probably so, but if it is clear that she plans to leave at a particular point, these indicia would not establish a Texas domicile. It is, after all, the person's intent that is the test. The practical facts described in Gordon represent evidence that can be useful, or at times, deceiving, in trying to prove that subjective fact. Very likely the Gordon court's fundamental reason for concluding that Susan Gordon had acquired a domicile in Idaho, though not too clearly articulated in the opinion, was not her Blue Cross membership or her apartment in Rexburg, but the fact that she simply didn't know what she would do after she finished school. 8. Corey's case. In light of the principles discussed above, what kinds of questions would you want to ask Corey, our plaintiff from Chapter 1, to determine his state citizenship? You would ask him about the practical facts of his life, such as whether he had changed his bank accounts, driver's license, and voting registration. But you would be particularly interested in Corey's plans after school. If he is quite clear that he is going back to New Hampshire or to some third state, he would not acquire domicile in Massachusetts. If he has little or no idea of his future plans, a court would likely conclude that he was in Massachusetts indefinitely, and therefore a Massachusetts citizen. 9. If diversity exists, which federal district court has jurisdiction? Gordon brought her suit in the Federal District Court for the Western District of Pennsylvania. Would the diversity analysis be different if she brought it in the Northern District of California? Or the Southern District of Texas? No, it wouldn't. The diversity statute, 28 U.S.C. Section 1332a, provides that the federal district courts shall have jurisdiction over cases between citizens of different states. If the plaintiff and defendant are from different states, any federal district court will have diversity jurisdiction over the case. The particular federal district the plaintiff chooses matters in determining whether the court has personal jurisdiction over the defendant or is a proper venue, but is irrelevant in determining whether the court has subject matter jurisdiction over the case. The court has diversity jurisdiction as long as the plaintiff and defendant are citizens of different states, and the amount in controversy requirement is met, as we will see later. 10. Diversity cases in state court. Gordon, from Idaho, brings suit against the Pennsylvania doctors in a state court in Pennsylvania. Would the state court have subject matter jurisdiction over the case? Yes. Recall a crucial point made in Chapter 1. The fact that a case could be filed in federal court as a diversity case does not mean that it must be filed in federal court. As a general rule, the state courts also have jurisdiction over cases within federal subject matter jurisdiction. Even if Gordon is diverse from the defendants, state courts have broad jurisdiction to hear tort cases as well, and Gordon may have strategic reasons for preferring to sue in state court. 11. Issue analysis, applying the domicile test. Here's a nice scenario one of the authors used to test domicile on an exam. Originally from Massachusetts, Ruggles drifted from one New England state to another, staying for a while and then getting itchy feet and moving on. At one point, he drifted up to New Hampshire, where he took a job on a lobster boat for the summer season. He had a contract to work on the boat for 6 months. During this period, Ruggles was injured when he was hit by Quan's car. May Ruggles sue Quan, a New Hampshire citizen, in federal court under the diversity jurisdiction? A suggested analysis. If a student wrote the following analysis of Ruggles' domicile, she would do very well. To invoke diversity jurisdiction, Ruggles would have to be a citizen of a different state than Quan. This turns on where Ruggles is domiciled, that is, the last state he has resided in with the intent to reside indefinitely, on the day he files suit. If, as the question suggests, Ruggles brings suit while he is still working in New Hampshire, he will likely be found a citizen of New Hampshire. True, he is a drifter, tends to move on after a while, and probably will leave New Hampshire at some point. But the question does not indicate that he has any specific plan to do so at a particular time. Although his contract is only for 6 months, the facts do not suggest that he has any plans as to what he will do at the end of the 6 months. Presumably, Ruggles' only plan at that point is to see what turns up, and if nothing does, then perhaps he'll move on. If this is so, Ruggles does not have a fixed future plan, is living in New Hampshire on an open-ended basis, and is domiciled in New Hampshire. Consequently, he cannot sue Quan in federal court based on diversity jurisdiction. 3. The complete diversity rule. Another question unanswered by the broad language of Article 3, Section 2 is how courts should assess diversity in a case with multiple plaintiffs or defendants. Suppose, for example, that Corey sues both Barristers Incorporated and Brummel, the bartender who hit him. Assume further that Corey is a New Hampshire citizen and Brummel and Barristers are Massachusetts citizens. The case looks like this. Corey, N.H. v. Barristers, M.A., Brummel, M.A. Is this a proper diversity case, even though 2 of the parties are Massachusetts citizens? Or suppose that Corey and Brummel are both from New Hampshire. Now the case looks like this. Corey, N.H. v. Barristers, M.A., Brummel, N.H. Is this a proper diversity case, even though there is a New Hampshire plaintiff and a New Hampshire defendant? Reading Mars v. Perry. The Mars case below addresses the complete diversity rule, as well as the problem of applying diversity jurisdiction to a case involving citizens of another country. In reading Mars, note that the court rejects the old common law rule that a woman automatically takes the domicile of her husband. Thus, it must assess the domicile of 3 parties, the 2 plaintiffs and the defendant. Consider the following questions in reading Mars. If Mr. Mars alone sued Perry, could he do so in federal court? Could he do so if he were domiciled in Louisiana? Why does the court conclude that Mrs. Mars did not acquire a domicile in Louisiana while there as a student? Is its analysis consistent with Gordon versus Steele? Note that at the time of Mars the amount in controversy was required to exceed $10,000, not $75,000. Students often find this case frustrating because it appears to contradict Gordon versus Steele. The Mars court concludes that the Marses did not acquire domicile because they were in Louisiana only as students and lacked the requisite intention to remain there. Consider whether the court adequately explains its conclusion that Mrs. Mars never acquired domicile in Louisiana. And, perhaps, ask yourself why the coursebook authors might include the case if it somewhat muddies the waters with regard to the domicile test. Mars v. Perry. 489 F.2 D 1396, 5th Circle 1974. Ainsworth, Circuit Judge. This case presents questions pertaining to federal diversity jurisdiction under 28 U.S.C. Section 1332, which, pursuant to Article 3, Section 2 of the Constitution, provides for original jurisdiction in federal district courts of all civil actions that are between, inter alia, citizens of different states or citizens of a state and citizens of foreign states, and in which the amount in controversy is more than $10,000. Appellees Jean-Paul Mars, a citizen of France, and Judy Mars were married at her home in Jackson, Mississippi. Prior to their marriage, Mr. and Mrs. Mars were graduate assistants, pursuing coursework as well as performing teaching duties, for approximately 9 months and 1 year, respectively, at Louisiana State University in Baton Rouge, Louisiana. Shortly after their marriage, they returned to Baton Rouge to resume their duties as graduate assistants at LSU. They remained in Baton Rouge for approximately 2 more years, after which they moved to Park Ridge, Illinois. At the time of the trial in this case, it was their intention to return to Baton Rouge while Mr. Mars finished his studies for the degree of Doctor of Philosophy. Mr. and Mrs. Mars were undecided as to where they would reside after that. Upon their return to Baton Rouge after their marriage, appellees rented an apartment from appellant Oliver H. Perry, a citizen of Louisiana. This appeal arises from a final judgment entered on a jury verdict awarding $5,000 to Mr. Mars and $15,000 to Mrs. Mars for damages incurred by them as a result of the discovery that their bedroom and bathroom contained two-way mirrors and that they had been watched through them by the appellant during 3 of the first 4 months of their marriage. At the close of the appellee's case at trial, appellant made an oral motion to dismiss for lack of jurisdiction. The motion was denied by the district court. Before this court, appellant challenges the final judgment below solely on jurisdictional grounds, contending that appellees failed to prove diversity of citizenship among the parties and that the requisite jurisdictional amount is lacking with respect to Mr. Mars. Finding no merit to these contentions, we affirm. Under Section 1332, A.2, the federal judicial power extends to the claim of Mr. Mars, a citizen of France, against the appellant, a citizen of Louisiana. Since we conclude that Mrs. Mars is a citizen of Mississippi for diversity purposes, the district court also properly had jurisdiction under Section 1332, A.1 of her claim. It has long been the general rule that complete diversity of parties is required in order that diversity jurisdiction obtain, that is, no party on one side may be a citizen of the same state as any party on the other side. Strawbridge v. Curtis, 7 U.S., 3 Cranch, 267, 1806. This determination of one state's citizenship for diversity purposes is controlled by federal law, not by the law of any state. As is the case in other areas of federal jurisdiction, the diverse citizenship among adverse parties must be present at the time the complaint is filed. The burden of pleading the diverse citizenship is upon the party invoking federal jurisdiction, and if the diversity jurisdiction is properly challenged, that party also bears the burden of proof. To be a citizen of a state within the meaning of Section 1332, a natural person must be both a citizen of the United States and a domiciliary of that state. For diversity purposes, citizenship means domicile, mere residence in the state is not sufficient.
Private person is no such thing. The courts only recognize the individual. The individual is recognized as a private individual, not a private citizen. A citizen is a member of a group or a firefighting force. It's also a belligerent. So it's also a taxpayer group among a member of a certain class. So, in a sense, the individual who is private might want to refer back to the earlier session of commonly accepted documents. So, just gave it to you right there.
Sufficient. A person's domicile is the place of his true, fixed, and permanent home and principal establishment, and to which he has the intention of returning whenever he is absent therefrom. Stein vs. Moore, 5 Circle, 1954, 213 F.2d 446, 448. A change of domicile may be effected only by a combination of two elements: A, taking up residence in a different domicile with, B, the intention to remain there. It is clear that at the time of her marriage, Mrs. Mars was a domiciliary of the state of Mississippi. While it is generally the case that the domicile of the wife, and, consequently, her state citizenship for purposes of diversity jurisdiction, is deemed to be that of her husband, we find no precedent for extending this concept to the situation here, in which the husband is a citizen of a foreign state but resides in the United States. Indeed, such a fiction would work absurd results on the facts before us. If Mr. Mars were considered a domiciliary of France, as he would be since he had lived in Louisiana as a student teaching assistant prior to filing this suit, then Mrs. Mars would also be deemed a domiciliary, and thus, fictionally at least, a citizen of France. She would not be a citizen of any state and could not sue in a federal court on that basis, nor could she invoke the alienage jurisdiction to bring her claim in federal court, since she is not an alien. On the other hand, if Mrs. Mars's domicile were Louisiana, she would become a Louisiana citizen for diversity purposes and could not bring suit with her husband against appellant, also a Louisiana citizen, on the basis of diversity jurisdiction. These are curious results under a rule arising from the theoretical identity of person and interest of the married couple. An American woman is not deemed to have lost her United States citizenship solely by reason of her marriage to an alien. 8 U.S.C. Section 1489. Similarly, we conclude that for diversity purposes a woman does not have her domicile or state citizenship changed solely by reason of her marriage to an alien. Mrs. Mars's Mississippi domicile was disturbed neither by her year in Louisiana prior to her marriage, nor as a result of the time she and her husband spent at LSU after their marriage, since for both periods she was a graduate assistant at LSU. Though she testified that after her marriage she had no intention of returning to her parents' home in Mississippi, Mrs. Mars did not effect a change of domicile since she and Mr. Mars were in Louisiana only as students and lacked the requisite intention to remain there. Until she acquires a new domicile, she remains a domiciliary, and thus a citizen of Mississippi. Point 2. Appellant also contends that Mr. Mars's claim should have been dismissed for failure to establish the requisite jurisdictional amount for diversity cases of more than $10,000. In their complaint, Mr. and Mrs. Mars alleged that they had each been damaged in the amount of $100,000. As we have noted, Mr. Mars ultimately recovered $5,000. It is well settled that the amount in controversy is determined by the amount claimed by the plaintiff in good faith. Federal jurisdiction is not lost because a judgment of less than the jurisdictional amount is awarded. That Mr. Mars recovered only $5,000 is, therefore, not compelling. As the Supreme Court stated in St. Paul Mercury Indemnity Company v. Red Cab Company, 303 U.S. 283, 288 to 290. He sum claimed by the plaintiff controls if the claim is apparently made in good faith. It must appear to a legal certainty that the claim is really for less than the jurisdictional amount to justify dismissal. The inability of the plaintiff to recover an amount adequate to give the court jurisdiction does not show his bad faith or oust the jurisdiction. His good faith in choosing the federal forum is open to challenge not only by resort to the face of his complaint, but by the facts disclosed at trial, and if from either source it is clear that his claim never could have amounted to the sum necessary to give jurisdiction, there is no injustice in dismissing the suit. Having heard the evidence presented at the trial, the district court concluded that the appellees properly met the requirements of Section 1332 with respect to jurisdictional amount. Upon examination of the record in this case, we are also satisfied that the requisite amount was in controversy. Thus the power of the federal district court to entertain the claims of appellees in this case stands on two separate legs of diversity jurisdiction: a claim by an alien against a state citizen, and an action between citizens of different states. We also note, however, the propriety of having the federal district court entertain a spouse's action against a defendant, where the district court already has jurisdiction over a claim, arising from the same transaction, by the other spouse against the same defendant.
Wait, did you hear that? It says had standing on two legs, like it's the sum claimed by the plaintiff controls if the claim is apparently made in good faith. It must appear to a legal certainty that the claim is really for less than the jurisdictional amount to justify the dismissal. The inability of the plaintiff to recover the amount adequate to give the court jurisdiction does not show his bad faith or oust the jurisdiction. His good faith in choosing the federal form is open to challenge not only to the resort to the face of his complaint, but by the facts disclosed at trial. And if either source is clear that the claim could never have amounted to the sum necessary to give jurisdiction, there is no injustice in dismissing the suit. Damn, that's a tongue twister, boy. Woo! Holy. So it's saying, in any sense, since he only attained so little of amount, he doesn't satisfy the need or show the bad faith to convince the court to award him, but he does show good faith in picking the court forum. But the question is, there is no justice when dismissing the suit when they had no jurisdiction to hear the claim or the amount for controversy. So basically, they concluded that the appellees properly met the requirement and with no respect to jurisdiction to the with respect to the jurisdictional amount. So upon the examination of the record in this case, they are also satisfied that the requisite was in the controversy. So they granted it to the person who appealed the case. So check this out. I'm gonna close this up because I'm gonna go back to my little thing. I just wanted to give you something to yap about. Check this out. So the first quarter of 2022. This is from here. I'll put the website link up there for you. And go to, probably heard of the site. Go here. Alright. So here, yeah, the written reprimands. And you got the supervisor failed to effectively plan and take action during use of force incident that occurred on his presence. Here's another one. Made threatening statements about his fiancée that were video recorded. While on duty, deliberately locked his partner in the bathroom and secured it so the partner could get out, so his partner couldn't get out as a practical joke. Oh man. Oh, look. Good faith claims. Are you serious? While on duty, he failed to qualify with his weapon during prescribed shooting required periods. So, in other words, he's a lousy shooter. While on duty, failed to register his vaccination status. Let's see. While on duty, failed to qualify with his duty weapon. In other words, he doesn't know how to handle his damn firearm. While on duty, he engaged in unwanted touching with an acquaintance, resulting in his being named as a suspect in a criminal report. While on duty, he failed to register, whatever. While on, I'll give him that one. I'll let him slide on that one. While on duty, he made unwanted comments sexual in nature to his coworker. Not acceptable. Law enforcement technician, written reprimand. So that's all they did to him was write him up. While on duty, he instigated an argument with a coworker by refusing to refer to the coworker by their name. Written reprimand, typist clerk. While on duty, he failed to register whatever again. failed to properly process court documents in a timely manner, resulting in the erroneous release of an inmate. Goodness gracious. Erroneous release of an inmate. Uh, while on duty, he was involved in a preventable traffic collision in a department vehicle while not wearing a seatbelt. While on duty, he failed to qualify with his duty weapon during prescribed qualification period. In other words, you still can't shoot. While on duty, he failed to qualify with his duty weapon during prescribed qualification period. In other words, he still can't shoot. He failed to register again and again and again and over. They just kept repeating it. Yeah, written reprimand. I'll just get written up. Fuck it. It don't matter. I've had that attitude before, buddy. It's a no winning situation, I tell you. There's no way to be. You should follow the rules. Look at this. While practicing firing, he failed to inspect and clear his duty weapon, resulting in unintentional discharge of the weapon. While on duty, he failed to qualify with his duty weapon during prescribed shooting required periods. While assigned as a patrol trained deputy sheriff, he sent an inappropriate text message to his co-workers, which created a unprofessional work environment. Sounds about right. While on duty, he was involved in a preventable traffic collision while not wearing a seatbelt. While on duty, he failed to properly clear the intersection while authorized to respond to a Code 3, and subsequently was involved in a traffic collision. While on duty, assisting in the use of force incident, while he was placed on duty with his weapon against the head of a suspect who was in control, or who was controlled. In addition, he failed to activate his body-worn camera prior to assisting. Man. Yeah, I'm sure he didn't want to record that, right? Look at this. While on duty, he failed to take proper action when observing two subordinates dealing with the recalcitrant inmate. While on duty, he failed to qualify with his weapon during prescribed shooting periods. He still can't shoot. They gave him 1 day suspension to go figure out how to shoot. He came back, still couldn't figure out how to shoot. Got another paid suspension. Just keeps on coming back with all these paid suspensions. While assigned as a training officer, he failed to conduct himself with a comprehensive investigation while on a robbery call. Whoa, sounds like a dangerous, reckless environment. Sounds like he neglected the standard of care. While on duty, he failed to take appropriate action during the report by failing to report a crime, pertaining information received from a crime victim. Sounds like something Mr. now Captain Bernal would do. Yeah, it's definitely something he would do. Take a promotion instead of a demotion. That sounds about right. I mean, I'm sure everybody would rather take a promotion, especially when they don't really have no reason to demote you. They'd rather thank you. Thank you, good job, here's your promotion. Well, by the way, just so you know, he really named you lieutenant in the lawsuit last year, so we're going to promote you and change your name this year, okay? Good job. Pfft. Unbelievable. Unbelievable. See, I bet you that's one thing that they didn't expect that I would find out. And yeah, that's the truth. So while he was on duty, he utilized county communications equipment for personal and or unofficial purposes. In other words, he accessed the database so that he can check out some hot chick that he liked, that he was stalking and whatever, and or he was selling information to somebody, whatever it was he was doing. But he was accessing the database when he had no authorization to do so. While on duty assigned to a courthouse, he made inappropriate comments regarding a judge. Huh. I wonder what they were. I wonder what are it, because I walked in with a piece of paper that was nicely written, and it was actually typed. It wasn't even handwritten. And they said, "Oh no, we can't accept that paper. It's inappropriate." So I'm just curious what the inappropriate comment was regarding a judge. While on duty carrying an unauthorized weapon, he carelessly handled the weapon, resulting in an unintentional discharge. See, he still ain't passed his firearm training. While on duty, he unintentionally discharged his duty weapon and struck another deputy. Whoa, sounds like friendly fire. Look out. Duck. Man, you don't see that every day. You hear me? He said, while on duty as a field training officer. So the field training officer failed. Field training officer failed to ensure that the trainee accounted for all the evidence and inmate property and failed to ensure that the criminal complaint and report documented all the recovered evidence and property. In other words, they carelessly left shit behind and didn't bother to gather property, probably the guy's money, big fat stack of money, his really nice cell phone that he probably had all kinds of really cool connections to. Who knows? 10-4, can we get a narcotics officer in the narcotics office because the alarm is going off? While on duty and attending schedule training, he made an inappropriate hand gesture and used offensive language. Huh, that's ambiguous as hell. I can come up with all kinds of hand gestures to give you. I can come up with all kinds of creative hand gestures to give you. And just to create something offensive. Hell, I can give you a friendly wave and you'll call it inappropriate, unfriendly, hostile, offensive language. On duty, he was involved with the preventable traffic location. Preventable. I'm sure he could have prevented it. I'm really sure he could have just sounded his sirens, turned on his lights, and people would have willingly moved out of their way. But because they have these capricious, tyrannical regime of enterprise assholes intermingled into one huge partnership, and they all shit in the same pot together and pay out of it together. The flowing enterprise is massive, and the muddy waters are deep. Holy shit, I tell you. But you get a 5-day suspension while on duty. He failed to take action where he observed a fellow sergeant handling a firearm in an unsafe manner. Well, what the? He failed to take action when he observed a fellow sergeant handling firearms in an unsafe manner. Failed to take action. Who was superior? Oh man. Automated fingerprint ID system. Yeah, he became aware of subordinate conduct. personal business while on duty and did not report it to supervisors as a potential policy violation. Ooh. Finger operator. Fingering on duty. It had too much residue on the printer. Made inappropriate comments regarding his relationship with another employee. See what they do while they just standing around doing nothing. Yeah. Ooh, ooh, ooh. Man, so this is just the first quarter of 2022. Yeah. Ain't this amazing? I mean, all this misconduct while off duty, he engaged in harassing and annoying behavior towards an ex girlfriend, resulting in his name being in a suspect as a criminal report. While on duty, he abandoned his assigned post without permission and left his work facility prior to the end of his shift without performing required security checks. So he just up and left whenever he wants and feels like it, because hey, I can do whatever I want, get away with it, right? While on duty, he knowingly submitted overtime records, indicated dates and times that he did not work. Instead, he stayed in the mop room playing on his computer. While he intentionally antagonized the trainee deputy by failing to provide clear, constructive instructions and utilizing humiliating tactics to teach lessons. And utilizing humiliating tactics. That's a nice phrase. That phrase has a really nice ring to it. Engaging in humiliating tactics to teach lessons. So the cop walks up on you while you're auditing or whatever the hell it is you're doing. And they begin in that abusive, humiliating, engaging behavior and start escalating with their tactics versus de-escalating the matters. They overreact with the strong emotional reaction with this anger, especially if they're criticized or confronted. So they use their anger and their authority and the gun on their hip to control you, when they really are just on a power trip because, whatever personal peculiarities that they may have, their own idiosyncrasies. So, when these engagements occur, they often escalate to unnecessary actions that take place, and the only action to continue is to escalate it as much as it could go, so that there's only one side of the story that they're really going to believe. I know it's a complex matter and most of us don't want to accept it, but it's beyond just the police here. See, we already know they're doing these things and getting away with it. We already know that. I think the first time I recorded the police was in 2009. I kind of knew a little bit of law back then, but really now I see how much shit that I did not know that actually took place behind the scenes. And now I see that this scheme is overall designed with a special idea, and it's a money-making market. It's a cycle of continuous operations, revolving engagements, and if you get caught in their revolving cycle, there's no coming out of it. they have it already all planned out. But see, they hope you don't sit down and educate yourself, challenge your perspective to a open, broader issue. You know, looking at some of the things that are actually taking place in the overall dynamics of law. You depend on constitutional law when the foundation of the Constitution in today's society is very, very long ways away from each other, and the arguments just don't sink anymore. They don't fit, and the idea is to keep you believing that that's the argument, and it's nothing more than an artful argument, and they'll call it legal reasoning. See, while he failed on duty, they should make this here, this this one here should be very strict. Policy. Whoa, jail time. But not for them. But yet, everyone's created equal, they say. But the equalness is clearly, I don't know, an illusion. It can't be said to be a reality. It, reality can't be defined in that. Let me show you this one here. So you got illegal tort. Alright. Respondeat superior refers to the legal doctrine generally used in tort. Anyway. Respondeat superior relates to the employer and the employee relationship. Creates what they call a vertical privity or a circular privity. One of the two. And the two definitions have distinct meanings and they're different. But they both mean a connection and a relationship between one party and another. And the doctrine of respondeat superior, an employee is liable and the employer is liable for the employee's conduct. So where you get hurt by a government entity or any other employee that works for an employer, their employer is liable to the same standard as the employee is individually. And if they're delivering a product, then that product has a value and the product is now a liability for the failure to use the product in the prescribed safe manner that the product was created and designed for, or designed to protect against the kind of harm that could occur if an actor is not careful when exercising discretion and using that product simultaneously. See what I mean? But with the restatements of torts is basically more of the common law theory of negligence and other black letter laws. And no, they don't use Black's Law Dictionary for definitions. I don't. I just use a regular Merriam-Webster's legal dictionary. Works perfect. They don't deviate from the meaning. The words mean what they mean. If you knew, like, A citizenship definition of a particular country, but it also means a membership. So you're beating around the bush with the first open word. But if you, Merriam-Webster, membership to a community, and individuals' response to membership in a community, are they private or public? So that's interesting. A bill with that. That's just. Huh. Why? What's the difference between being a U.S. citizen and a U.S. national? Can there be a person who is a U.S. national but not is a U.S. citizen? Let's see what the answers are. A national is a green card and a citizen but not born here. Since you just get a secret clearance. Huh? What? What secret clearance? Well, I could tell you the answer. Tell you the answer. I'll tell you the answer. Here you go. Here's your answer. Term national means a citizen of the United States, or B, a person who, though not a citizen of the United States, holds a permanent allegiance to the United States. The term naturalization means conferring of nationality of a state upon a person after birth or by any means whatsoever. 14th Amendment. Here, national would have a crewman. He would have a border crossing identification card that be designated to an alien who is lawfully admitted for business or resident permanent purpose, residence, whatever. An alien who is lawfully a resident of a foreign contiguous territory. I struggled with that one for a long time. That one was a struggle for a real long time. But contiguous territory is just basically the states between the several states. And the connections and the borders in between the states, they're connected, they're contiguous. And the borders with Canada and Mexico, they're contiguous between each other. And you can't leave the country without a passport. You're stuck in the country that you live in. You could travel in between the states, but you cannot wander outside of the country without the passport. And the difference is, for the passport and the border crossing identification card, which is a passport card, the difference is you give you go wherever you want. You can go to Canada, you can go to Mexico, wherever you want. But if you only have a driver's license, I mean, sure, maybe you can get on the other side of the country, but you're gonna have a hard time getting back in. So, in a sense, you're a prisoner to your own country. I can show you that. I can show you that too. There. Probably want me to show you, but I'm gonna hang up. I just thought I'd just drop in and just give you some action. Watch this. Show you what else I was gonna show you. Contiguous territory issuances may be prescribed by houses. Any identifier, system of records, and control or under control of any agency. And matches research statistic projects and specific data concerning the rights, benefits, and privileges of individuals. Using records predominantly relating to federal personnel that are performed for routine administrative purposes, subjective to guidance and provided by Director of Office Management Budget pursuant to subsection 5, or conducted by an agency using only records from a system of records maintained by that agency. Must be a covered agency. So you want to talk about some privacy here? Huh. Source agency. Any agency discloses records contained in a system of records to be used by a matching program. Sounds like a credit check. Federal benefits program. Routine use, like routine traffic stops. Accounting and certain disclosures. Each agency, they must disclose their conflicts of interest records too. Oh yeah. Maintain all records which agency uses in any determination about any individual with such accuracy, relevance to time, and completeness is reasonably necessary to assure fairness to the individual in determinations. Agency rules. Carry out the provisions of this section, where an individual can be notified in response to his request, if any. So, where can I serve you your papers at? What a life. Let's see, make sure I close everything up here. There you go. Well, sorry, I didn't communicate with anybody. If anybody commented, I wasn't looking at any comments. I was just shooting the shit, brainstorming. I was letting the muddy, murky water spew all over the place. You know, if I was a white-collar criminal, I'd be disguised as a politician on a mission. I'd wear my suit, my tie like armor. My smile would be a weapon of mass deception. And then, as you can imagine, as a politician, I'd get up there on the podium and preach the virtues of freedom and justice, while behind the scenes, pulling the strings on the puppet show, designed to keep the masses entertained and oblivious, while I travel across the nation, drop seed after seed, sow seeds of destruction and flowers of hatred. For no reason, then I get you to battle each other and then vote for me. Go against your own interests and you don't even know it. Good luck. That American dream, right?